I'd also state just before we start that we will be recording this event, and the recording will be up on the law school's website, and you can avail of it there at any stage. So the focus, as you know, of the webinar today is the German Federal Constitutional Court's ruling that the German government and the legislature violated the constitution by failing to monitor properly the ECB and especially its public sector asset purchase programme. And also that the ECJ ruling on the same matter wasn't binding on it. So this isn't clearly just a dispute of a technical nature. It's been described as an act of constitutional rebellion by one commentator. And the implications, it is said, of this are extreme, where you have, again, as another commentator said, a German court out of control. So I think to tease out these issues and the implications, I'm really honoured to have four excellent presenters and experts on this. So you have the detailed biography, I believe, but I'll just give you just a brief introduction to them. Gavin Barrett, starting, is the Jean Monnet Professor of European Economic and Constitutional Law at UCD. Dave Fennelly is a professor in our School of Law in Trinity, and he specialises in European and international dimension of public law. Georg Winger is the Professor of Law and Economics at the University of Hamburg. He's also a visiting professor at Oxford and a colleague of ours at the European Banking Institute in Frankfurt. Finally, Bridget Lavin is a director and professor of the Robert Schuman Centre for Advanced Studies in Florence. And we will start with Gavin. So Gavin, the floor is yours. Thank you.
Great. Thank you very much indeed, Blanaid. I suspect there'll be a degree of overlap between us all, so I hope I don't tread too much on the territory of other speakers. And by the way, I do tend to go on a bit, so do feel free to cut me off at whatever moment you feel is apposite. It's hard to think of cases like the Vice case without thinking in terms, I think, of revolutions and counter-revolutions. The European Court of Justice in Costa and Enel, in which it established the doctrine of supremacy, I think can be called a case that involved a revolution, and that case followed hard on the heels of its own earlier ruling in Van Gengen-Loos, in which it had established the doctrine of direct effect, the idea that European Union law confers on individuals rights which national courts must enforce. In passing, both the Van Gengen-Loos and Costa cases also explicitly enunciated, by way of a stepping stone to their more famous findings, the doctrine of the autonomy of European community law. In other words, the idea that it's not a public international law or a form of domestic law, but rather that the EC law system was, if you like, on entering into force, had created its own legal system. And implicitly in both Costa and Van Gengen-Loos, the Court of Justice asserted implicitly, or otherwise, at least three things. It decided that it was for EU law and the Court of Justice to identify the court and the legal system which has power to answer the direct effect and supremacy questions. And the court doing that is commonly called its assertion of competence. In other words, saying that it gets to appoint the referee to decide on who adjudicate on direct effect and supremacy. It then made that adjudication in favour of itself and the system of EU law. In other words, it appointed itself the referee, and it held that it, the European Court of Justice itself and EU law, could provide the answer to the direct effect and supremacy questions. Another way of putting that is that it adjudicated that it had competence. And then finally, it got to the easy bit. The court decided the main issue in each case, that community law was directly effective in Van Gengen-Loos and supreme in Costa and Enel. Now, the facts of Costa and Enel involved an electricity bill for an amount of less than €1. Those of Van Gengen-Loos concerned the rather technical issue of the legality of the taxation reclassification of an obscure chemical called urea formaldehyde under Dutch law. And I think factual backgrounds like that may have concealed the colossal revolution in the constitutional legal order in Europe that these rulings asserted had taken place. Now, the European Union has come to be regarded as a powerful entity on the international stage, and it is, but I think it's frequently unappreciated, at least outside legal spheres just how dependent economic and political power is on the law. The European Union has no army, it has a minuscule budget compared to any national federation, a tiny civil service, and European integration is to a huge extent integration through law. And as such, it hangs almost entirely on one slim thread, the willingness of national courts to follow the lead of the European Court of Justice. If that thread breaks, the mighty economic and soft power that is the European Union in the modern world crumbles to insignificance, losing most of the power that it has. And that the value of that power isn't to be underestimated, since it seemingly includes the power to guarantee peace in a continent formerly ravaged by seemingly interminable violent conflicts. So the revolutionary regime envisaged in Costa and Enel is thus a fragile one, and it's also necessarily, as Joseph Weiler has written, bidimensional. One dimension is the elaboration of the parameters of the doctrine by the European Court, but its full reception, the second dimension, depends on its incorporation into the constitutional orders of the member states and its affirmation by their supreme courts. Now, returning to our three-part assertion by the Court of Justice, competence, 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 and the supremacy direct effect questions, national courts have really only ever agreed to the third assertion, and sometimes, as we shall see, not even to that. Few have ever agreed to what we have identified as the first and second implicit assertions of the court in Costa and Van Gengenlo's competence, competence, and competence. Now, that brings us to the Bundesverfassungsgericht, because the German Federal Constitutional Court has over many years earned a deserved reputation as the national court against whose decision there is no judicial remedy under national law, that is simultaneously least likely to engage in its obligation to make references under Article 267, and most likely to qualify its own acceptance of the doctrine of supremacy as enunciated in Costa and Enel. In fact, it's only ever made two Article 267 references. One was what I hope I'm not being unfair by calling its rather aggressive reference to the court in the Gauweiler case, and I'm sure Georg will be talking about that later on. And the second, the reference which the court made in Weiss, where Karlsruhe responded to the opinion preferred to it by the Court of Justice by rejecting it, without actually giving the court in Luxembourg its opportunity to pronounce again, which is something the Italian constitutional court did in a similar situation. But Clarke and de Borca have formulated a useful set of questions that can be deployed as a kind of a useful four-part test of the extent to which national courts accept supremacy. One is quite simply whether a member state court accepts the supremacy of EU law within the field of EU competence, and that's something they usually do. A second is its conceptual basis for doing so. Is it because of the reasoning offered in Costa, or is it on the basis of national legal provisions? It's generally, if I can give a tip or a hint, it's generally the latter. A third issue is whether the national court accepts the implicit claim by the European Court of Justice of competence, competence. So something virtually none of them do. And a fourth is whether a national court places limits on its acceptance of supremacy on grounds like human rights, ultra vires concerns, or questions of constitutional identity. Now, surveying briefly the pre-Weiss jurisprudence of the Bundesverfassungsgericht, it's plain, first of all, that German courts do accept the supremacy doctrine, or as they would have it, the primacy of European Union law as an effective functional necessity of the integration process. As the court has put it, the primacy of application, as they describe it, follows from Union law because the Union could not exist as a legal community if the uniform effectiveness of EU law were not safeguarded in the member states. That's from the Honeywell ruling of the Bundesverfassungsgericht. To look at our second test, the reasons why the Bundesverfassungsgericht accepts the supremacy of EU law are founded, apart from the functional concerns, which actually form a lot of the basis in Costa itself, actually as well, solidly on the text of the German constitution rather than on the text of the TEU and the TFEU, and in particular on the Europe clause in the German constitution. The third litmus test of the degree of acceptance of supremacy of EU law, as to whether the national court accepts the implicit claim of the ECJ of competence, is clearly rejected by the Bundesverfassungsgericht. And you can see sufficient evidence of that in the Brunner case, the Maastricht case, and indeed in Honeywell. But the rejection of any competence is actually explicitly asserted in Weiss, because in Weiss itself, the court said that the basic law explicitly, it said, prohibits conferring upon the European Union law the competence to decide on its own competences. But the most interesting part of our four-part test of the degree of acceptance of the supremacy doctrine for present purposes concerns limits, because the German Federal Constitutional Court has applied limits to supremacy over time. The first limit came in the 1974 Solange case, which was actually the Internationale Handelsgesellschaft case referred back to the European Court of Justice. That's the case in which the European Court of Justice indicated that European Union law took primacy even over national constitutional rights. Well, when that went back to the German courts, it ended up ultimately before the Bundesverfassungsgericht, and that conditionalized its acceptance of the ECJ ruling, the Court of Justice ruling, by holding that the guarantees of fundamental rights in the Constitution prevail as long as the competent organs of the community have not removed the conflict of norms in accordance with the treaty mechanism. Now, perhaps encouraged by the development of fundamental rights as a general principle of EU law, the Bundesverfassungsgericht then in Solange II, the second Solange case, actually softened its approach, and basically they lightened the review. So there was this kind of rather aggressive approach initially in Solange I, if I call it that, and then in Solange II, it backed down to a certain extent, encouraged by the recognition of fundamental rights as a general principle of European Union law. And it said that the Federal Constitutional Court would no longer exercise its jurisdiction to decide on the applicability of secondary community legislation within the sovereign jurisdiction of Germany, and it would no longer review such legislation by the standard of the fundamental rights contained in the Constitution, as long as they were generally, their essential content was generally safeguarded at European level. Second limitation, and one very relevant for the Weiss case, appeared in the Maastricht case, or the Brunner case. And in that case, it was asserted that there were competence limits to the extent of Germany's submission to primacy. Now, the Brunner case was uncompromisingly statist and intergovernmental. It stressed the language of national sovereignty and asserted the position of the states as die Herren der Verträge, the lords of the treaties. So if we can deem Costa and Enel a revolution in pursuance of a supranational Europe as the only possible way to guarantee a functioning common market, itself a tool in pursuit of a higher ideal of lasting peace, then Brunner was an unsympathetically, and if I may be critical enough to say it, magnificently, I think, myopic conservative counter-revolution, countenancing nothing less than the maintenance of national states in all their Westphalian grandeur of masters who would brook no rival at the end of the day. And the validity, the court held, and application of European law in Germany depend on the application of law instruction of the Accession Act of German law, and Germany thus preserves the quality of a sovereign state in its own right. An interpretation, it said, by the Court of Justice couldn't have the effects of extending the treaty. Such an interpretation would not produce any binding effects for Germany. So the stakes of this competence review were there for all to see. A Germany whose courts felt competence bounds were being overstepped would regard itself as legally exempted from any binding effects. Later, though, again, a bit echoes of Solange II, the Bundesverfassungsgericht withdraws somewhat, just as it had in relation to the fundamental rights case law. So in Honeywell, the Bundesverfassungsgericht continues to maintain its right to apply ultra vires review, but it does so in far gentler language, and it now indicates to want to stress that the relevant limits would be broadly drawn, holding that, for example, ultra vires review may only be exercised in a manner which is open towards European Union law, and that it could only be exercised by the court if it is manifest that acts of the European bodies and institutions have taken place outside the transferred competences. It also imposed an obligation on the Bundesverfassungsgericht to make references to the Court of Justice, which is what led to the Gauweiler and Weiss cases. The extent to which that promise of moderation has been held to, I think, is probably questionable now in the light of the Weiss case, but it was made in that particular case. And the Bundesverfassungsgericht also came up with the doctrine as well, which was also cited but not deployed in its ruling in the Weiss case, which was that the doctrine of state identity. As a third limit on its acceptance of the doctrine of supremacy. State identity is the notion that there's a core content to a national constitutional order that is inviolable. And in the German context, that doctrine is most closely associated with the Bundesverfassungsgericht's Lisbon ruling. And the court, in that case, actually produced a long list of what we call Staatsaufgaben, or necessary tasks that a state must fulfill. And I'm afraid it has been rightly, I think, excoriated since it provided absolutely no theory or system for that particular list. Sorry, Blanaid. Yeah. Oh, keep going. Okay, grand. It provided no theory or system for that list. In the rather damning words, I think, of Halberstam and Myers, the theory of the court is a post hoc argument in support of a preordained result. It wanted limitations in European integration, and that approach gave it those limits. Now, what else to say before we get briefly to the Vice judgment itself? I know others are going to go into the judgment in more detail, so I'll just very, very briefly make one or two points. One of them is that over the years, since so lange was decided in 1974, the Bundesverfassungsgericht, I think it's fair to say, has engaged in an extraordinary amount of conditionalizing of European integration and some very ominous sounding warnings. And if one keeps, I think, saying that one will only accept something so lange, as long as an ever-lengthening series of conditions is met, there's a very real danger that you paint yourself into a corner. And in cases like so lange 2 and Honeywell, the court managed to wipe away some of the conditionality it had painted around itself. And yet there are risks, if you continue to engage in that kind of behavior, that such an escape will not always be so easily effected. Secondly, implicit threats of the kind that the Bundesverfassungsgericht has been making since at least Brunner come at a risk to the party making them. And that is that if the party follows through, the consequences may be devastating for the future of Europe, since they involve abandoning a system that has protected peace and prosperity in Europe for over 6 decades. Yet if they do not follow through, they're accused of crying wolf and thereby lose face. It's hard to believe, I think, that the Bundesverfassungsgericht in Gauweiler didn't feel some humiliation in swallowing hard and then rather meekly accepting the ruling of the Court of Justice, having first sent it what can only be described as a fairly aggressive sounding reference in the first place. And yet it was the court that had put itself in that rather awkward situation. A second and final observation, and I'll leave that before leaving the ground to others, is a second observation I think is worth making, is that prominent members of the Constitutional Court, including its now retired President Andreas Voskuhle, for long rejected the idea of hierarchy in the European judicial order. So in this vision, instead of there being a hierarchy in European Union law with the Court of Justice sitting at the top, there's what he refers to as multi-level cooperation. The vision that's put forward is rather like a mobile hanging over a child's cradle in which every element balances every other element so that the structure remains in harmony. And that vision has its attractions, especially if one has concerns about the rather unlimited nature of the power of the Court of Justice at the centre of the EU legal system. The difficulty with the vision, though, and one never adequately answered, I think, by Voskuhle, is that if every constitutional court in Europe adopts this approach, the model overbalances. The European Court of Justice can't possibly respond to the legal demands of 27 different legal systems, each establishing conditions of its own relating to supremacy. And the Bundesverfassungsgericht in Weiss actually acknowledged that particular danger, but effectively moved on from it with a metaphorical shrug of its soldiers and an assertion belied by the outcome of the case that collisions would be rare. If, on the other hand, the balancing exercise is only carried out by some constitutional courts, then the question of legitimacy rears its head. Who appointed the Bundesverfassungsgericht to carry out this role on behalf of all the national legal systems? Why should the European legal system bend to the demands of a German court and the German legal system rather than that of others? So I think the model fails to convince. Now, I managed to keep on talking for so long that I didn't actually get around to going through the actual details of the ruling itself. Happy to go into those if anyone needs that, but I'm sure the other speakers are well capable of doing that. So happy to see the ground there or to go back on it if that's needed.
Okay, thank you very much, Gavin. It's just so comprehensive and there's a huge amount to digest, and I no doubt some of these issues we can discuss at the end of the Q&A session. So I'm going to turn to David Fennelly just initially to look at the ECJ aspect, and then we'll turn to Georg Ringe to look at the ECB aspect. So David, the floor is yours. Thank you.
Thanks very much, Blanaid. Pleasure to participate today. Gavin has already covered an awful lot of ground, so I'll pick up the thread from Gavin's sketch of essentially a potted history of supremacy in the EU legal order. And the PSPP judgment of the German Federal Constitutional Court has been widely recognized as a very problematic judgment, but some have suggested it goes further than that and in fact could lead to the unraveling of the EU legal order itself. So in my brief contribution today, I want to consider that. And in order to consider that, we need to put it in that context that Gavin has just shaped. There's a long history of dialogue between the Federal Constitutional Court on the one hand and the Court of Justice. Some of that has been hugely significant in the constitutional development of the Union, particularly in the field of fundamental rights. What's been unusual about that dialogue is that for many of the decades, it was indirect. And it's only in the recent cases that Gavin has mentioned that we now see the Federal Constitutional Court actually making references to the Court of Justice for guidance on these particular issues of EU law. That can be seen as a positive development, part of this multi-level cooperation that Voskula has spoken about, the former president of the Constitutional Court. But it also brings the risk of direct conflict between the Court of Justice on the one hand and the Federal Constitutional Court on the other, something that we've managed to avoid so far. The Federal Constitutional Court, as Gavin has laid down, has already set out, has set certain markers, no-go zones. If the EU were to trespass on the competence that is retained by member states, if the EU were to interfere with the constitutional identity of the member states in its core form and so on, but has never actually invoked those limits until this case. And that's the significance of this case. In the CJEU judgment, the Court of Justice judgment in Weiss, we have a serious engagement with the issues that had been referred by the German Constitutional Court. Now, the reference itself, curiously, had made certain reservations about whether the Court of Justice's judgment would be final, and the Italian governments had raised questions about that particular point. But the Court of Justice, in its substantive judgment, deals with the core issues. In particular, it deals with the concern raised by the German Constitutional Court about competence and whether the PSPP went beyond pure monetary policy into the sphere of economic policy, which in large measure was retained by the member state. Addressed those issues and concluded that the particular measures did indeed fall within the scope of monetary policy. Secondly, it addressed the concerns about the proportionality of the ECB decisions. And in fact, by Court of Justice standards, it dealt with that question of proportionality in a good bit more detail than it usually would. It ultimately upheld those decisions and referred the matter back to the National Court. That's where the problems started to re-emerge. The German Constitutional Court conducted an oral hearing after the Court of Justice judgment. It heard further evidence from experts on the particular issues. And then it analysed, some might say, tore apart the Court of Justice judgment. But it's in the detail of the judgment, we see some signs that aren't as bleak as the rest of the picture might be. The court does reaffirm that it would only ever intervene and deem acts of EU institutions, including judgments of the Court of Justice, to be ultra vires in exceptional cases where there's a manifest breach of competence. So here it seems to be going into the territory of invoking its competence lock, that the EU is trespassing into the competence of the member states. But what is curious about the Federal Constitutional Court's judgment is that it modifies its competence lock. It is a competence lock with a proportionality twist. So broadly speaking, the Federal Constitutional Court accepts that the particular decisions may fall within the scope of monetary policy. But it says that the Court of Justice erred because it should have verified not only that it was within the Union's competence or the ECB's competence, but also that it went no further than was necessary to pursue the monetary policy objectives. So it's that proportionality twist on the competence lock, which is the real problem in the German Constitutional Court judgments. Here, the court then says, well, the Court of Justice's analysis of proportionality was incomprehensible, and we have to apply our own much more rigorous, much more vigorous assessment of proportionality. Here we are unsatisfied that the ECB has properly verified the proportionality. In particular, and this is one of the ironies of it, it says the ECB hasn't sufficiently had regard to the economic effects of these monetary policy measures. And then it ultimately concludes that the ECB decisions were ultra vires, but also the vice judgment of the Court of Justice itself, which had upheld those decisions. And it says that the ECB must prepare a more detailed assessment of proportionality for this elaborate PSPP regime to stand. But in doing so, of course, the Federal Constitutional Court, as Gavin has pointed out, attacks one of the foundations of EU law. And one has to wonder about what is really going on here, particularly in light of the trial by media, which was conducted by both courts, but particularly some members of the Federal Constitutional Court after this particular judgment. There seems to be a lot of institutional ego at play. The judgment is certainly deeply problematic. It's not convincing on its own terms. It's a curious case in which to finally invoke this limit, this competence lock, because there doesn't appear to be a manifest breach of competence. And the timing in the middle of the COVID-19 and the new economic crisis is most unfortunate. But at the same time, I'd caution against some of the alarmist readings of this judgment. Is it really a profound threat to the EU legal order? Certainly, if it were to be played out across the member states, it would be so. But we are very far from that scenario, and even the Federal Constitutional Court doesn't suggest anything of the kind. What we do have is a fairly blatant breach of EU law. They're deeming the judgment and the ECB decision ultra vires, and they are not re-referring the matter to the Court of Justice as they should, as Gavin pointed out, the Italian Constitutional Court, especially where their criticism is one of comprehensibility. So under the treaties, the Commission has the tools to compel a member state to comply with EU law when it's in breach. It can bring infringement proceedings. Whether or not it's desirable politically for it to do so is another question. Consistency may demand that that happens, but of course this is an area of particular political and legal sensitivity, especially because we're talking about an independent court under the domestic constitutional system. And ultimately, the infringement proceedings, if the matter is rectified within the 3-month period, may turn out to be something of a damp squib if they are brought. But certainly the EU legal order has its tools within its arsenal to remedy the breaches of EU law. Just very briefly, what about the broader contagion effect, if we can call it that, of the judgment? Is this playing into the hands of the autocrats? Certainly it got a strong reaction from the Hungarian and Polish governments. And many have said that this rebuke by the Federal Constitutional Court will give a license to the courts in those jurisdictions to ignore EU law. That's a completely understandable and proper concern. But again, we have to recognize there's a difference between the underlying problems. Here we have a breach of EU law in a particular case by one of the German institutions, an independent institution under the Constitution. In Hungary and Poland, the issues are of a much more systemic nature. And the courts or the governments in those jurisdictions don't need the Federal Constitutional Court judgment to have the rhetoric and the tools to attack EU law. And we see that today in the Court of Justice's judgment on the Hungarian foreign NGO law. The second broader question is this finally the showdown between the courts, the fight for who is the ultimate arbiter, the competence issue that Gavin has already alluded to. And certainly it points up the tensions. Some have suggested, Sarmiento and Weiler, that there's a need for this mixed grand chamber to adjudicate upon these issues. But just very briefly to conclude, I would say that perhaps as lawyers, we focus too much on the courts to resolve these difficult constitutional questions. Who has the final say is a very contingent thing indeed. On the whole, the dialogue between the Court of Justice and member states' apex courts has worked quite well. Inevitably, there will be problems and tensions. This case is a manifestation of that. But on the whole, it hasn't been an entirely bad thing. And the EU institutions, as I've already said, wield very considerable powers to protect their prerogatives, including the Court of Justice with its Charter of Fundamental Rights. Secondly, the dialogue between the courts is only one part of the more complicated constitutional landscape. And we see that in the political response to this judgment. There's been a significant ramping up of EU financial intervention post-COVID, an increase in the own resources decision or budget part of the MFF in a way that we've never seen before, a rescue plan of a kind that is unprecedented. So where does this leave us? Yes, the FCC judgment is deeply problematic and needs to be taken seriously, but it's important not to overstate its significance. As with so many other debates in the EU right now, including Brexit, there's a real need for de-escalation. And I think we could all take a cue from Chancellor Merkel's response to the judgment. She noted the judgment, she criticized the response of the Hungarian and Polish governments without naming them, but she, in the meantime, focused her energies on the task at hand, keeping the ship afloat. Thanks very much, Blanaid.
Thanks, David, for that clarity and insight. Georg.
Yes, hello. I hope you can see my slides. Thanks so much for having me. It's great to be with you in Dublin. I wish I was there in person, but you know, one of the nice side effects of the crisis is that you can participate in events which are so far away without traveling. And my wife always asks me in the evening, so where were you today? I can always say, oh, I was in Moscow, or I was in Boston. So tonight I will say I was in Dublin, and it's great to be part of this debate, and hasn't, to my knowledge, been a national case that has had so vibrant repercussions in being discussed in events in other countries like this. So it's great that you're doing this sort of thing. So I want to leave the fantastic talks from Gavin and David. I'm not an EU lawyer. I'm more interested in the banking law and financial law implications of this judgment, and talk a little bit about the implications for the ECB, but also mostly for the current COVID-19 fighting that's ongoing. What's the main problem for the financial market? The main problem is that even though I concur with David that, you know, maybe it's not the end of the world, it does erode trust in the ECB. As soon as there's one player that says, you know, this is what you're allowed to do and this is no further, right? We have now an institution that is speaking up to the ECB and setting limits to what it's allowed to do. Whether legitimately or not is another question, but it does undermine the possibility of the ECB to do what it would like to do. And the ECB, if you remember, you know, we've just come out of this dramatic financial crisis from 10 years ago. The ECB was the only player, arguably, that really had strong powers to tackle those crises. And psychology matters so much in this circumstance. You know, remember Mario Draghi saying whatever it takes, and that solved the entire sovereign debt crisis. If that's not psychology, then I don't know what, right? So, and as soon as we undermine that trust that the ECB is really powerful and can do whatever it takes, then we will also undermine trust in that institution, right? And that, I will come to that in a moment, also has implications for today's corona crisis fighting that is going on. The second implication is a political one, and David has already hinted at it. I'm sure that Bridget will also talk about this, that there is the suggestion, as David was saying, that some Eurosceptic regimes feel that they are no longer required to comply with case law or with any other instruction from the European Commission. If they say, you know, look, the Germans, they are no longer being bound by anything that the ECJ is telling them, so we can do the same. And in fact, this has already been suggested. This is something to watch, but I wouldn't be surprised if at least that argument is being made, right? And the next time that somebody is reluctant to comply, and we have millions of times we have situations where member states don't comply with what the EU is telling them, right? Don't implement directives, I don't know what, right? And then there are so many situations, and this will be an additional argument that they can and that they will use in a time where Euroscepticism is already growing everywhere. That brings me to the long-term consequences, and the new purchase program that the ECB has just launched a couple of weeks ago and extended now is the PEP, the Pandemic Emergency Asset Purchasing Program. This is the bazooka that the ECB under the new leadership by Madame Lagarde has now fired. And this has proven to be a very powerful target in addressing the corona crisis. But I suspect this will be the new target for next litigation around, right? And in fact, just this morning, it was in the German news that the AfD, the sort of right-wing populist party in Germany, is, you know, preparing a legal challenge to that PEP program. Right? Mind you, I mean, just to make this all clear, the current case that we're discussing today, the Weiss case, was on a different asset purchase program. Well, everybody knows that, I know, but it's just important to clarify again. It was about the PSPP, a program that was launched in 2015, so one of the many post-financial crisis asset purchase programs. And there are some differences between the two, but if anything, then these differences mean that the PEP program is maybe even the more attractive target than the PSPP was. The main difference is that the PEP is somehow deviating from the capital key allocation of EU member states, meaning that the PSPP, the one that was subject in the Weiss decision, was allocating the asset purchase powers depending on the economic contributions of the Euro member states. So they would, the biggest share would buy German bonds, and then they would buy, I don't know, French bonds and Italian, depending on the capital key of Euro member state. Sorry, and the PEP. The new coronavirus program is sort of explicitly giving up that restriction. So they're saying we no longer feel bound by this capital key. We will buy securities from all over Europe, and implicitly making the point, of course, that this is the much more effective way of targeting a crisis, because they can move money to those countries where the help is mostly needed, right? And that makes sense, right, at the face of it, because Germany has come through the crisis relatively well. But look at Italy or Spain, you know, this is where the money is really needed. But legally speaking, that makes a big problem, because this may indeed then ultimately be considered as being prohibited state financing if money is directly moved to those countries. And if you look at the Weiss decision, the Bundesverfassungsgericht decision, the argument that the PSPP program sticked to the capital key allocation was the main reason for the German Constitutional Court to not classify it as state financing. Right? So I'm saying here, this is problematic, right? And the next litigation is on the horizon, and the PEP program will likely be attacked, whether successful or not. But when you take the measurement, the yardstick that's been used in that May decision, then I think there's no other way to say the PEP is even another next problem. But I want to end with a more, or not end, but I'm almost done, but I just want to also flow in a more positive sign, a more optimistic view after all this court bashing here, because the positive silver lining may be that this decision may force us to rely less on the ECB. This may be the virtue of the whole thing, that we cannot be sure that the ECB is really doing whatever it takes, simply because it's not allowed to do so. The ECB was the only crisis fighter, as I was saying, but it's only been buying time, really, right? And any really real reform of the EMU hasn't been attempted, simply because policymakers were suddenly relieved, oh yeah, the ECB will do everything for us. Right? Now the first shadow is hanging over the ECB, and this may pressure policymakers to spring into action and to really address the issues that need to be done. And one attempt to already see this happening is the latest initiative by France and Germany that's now been pushed by the European Commission as well. The first step, as some say, towards a fiscal union, to launch a European recovery fund, so allowing the EU to borrow itself for the first time on a massive amount and using that to crisis fighting is really a first step. Some even say already, the first movement of a Hamilton moment in Europe. I'm less optimistic here, but it's already a significant step. And I think it's no coincidence that this directly comes just days after that decision. It's probably been prepared much in advance, but the German Constitutional Court's decision may be the ultimate tipping point for this to spring into action. Final point from my side is the interesting question of how should the ECB respond now to that decision. What should they do? The official line is, when you look at statements from the ECB, we don't respond at all. We shouldn't actually give in, right? We shouldn't produce that stupid proportionality statement, because otherwise, if we do that, then we implicitly recognize that the German Constitutional Court has something to tell us, right? Has the right to instruct us to do certain things, and that's something they don't want to do. So if they stick to that line, there will be the clash of trains. A compromise solution may be what if the German government drafts the proportionality assessment? What if other people have suggested? What if the Bundesbank representatives in the ECB governing council do that? Would that be sufficient? I don't know. It's hard to see how this can be, standing up to what they have been explicitly been instructed to do. But then one has to be pragmatic, right? As David was saying, Merkel is very pragmatic, and I think that there will be a compromise solution somewhere. The final word is what we've already heard as well. The logical conclusion will be, Brussels will take Germany to the ECJ again. And then the funny situation will be that the ECJ will rule again on the whole thing. So this will be an eternal ping pong game, which I think is in nobody's interest. So I hope we find a pragmatic solution. And I want to end with that rather optimistic note. Thank you so much.
Thank you, Georg. I think there are a lot of issues. Again, there are a lot of questions that hopefully we'll have a little time to discuss. Bridget, if I may turn to you just to conclude.
Thank you. Well, I'm a political scientist and not a lawyer, and it's a great pleasure to be amongst lawyers for our discussion today. I think what I could most usefully do is bring us back to the nature of the EU as a political order and a polity, and the role of law in that political order. In terms of political order, the EU is extremely young. This is not a mature political order or political system. Secondly, it has a dual compound character in two ways. It consists of the whole and the parts, the member states and the collective, but also states and their peoples. So there's a duality that runs through the EU. It has federal characteristics, but is not a federation. It has state-like characteristics, but is not a state. So the EU is distinctive. I wouldn't use the term sui generis because it can be compared to other forms of political order, but it is distinctive in the combination of function and identity and territory. And unlike the nation state and the process of state formation, the EU is remarkably weak in terms of the traditional sources of coercive power: army, police, all of the resources that states can call on. But it also is, unlike nation states, it doesn't depend on a convergence of identity and territory. Rather, it combines multiple identities into a collective. And there is a weak EU-level identity emerging, a weak political community, but it's extremely weak. And this has consequences for the EU as a political system, and particularly for the role of law. Why do I say that? What is the glue that holds this system together? What can it not be stripped of, or else you don't have an EU? And I would argue that it is law and shared institutions are the glue that keeps this system together. And out of this, they have created a level of interdependence, both economic and political, that also adds to the glue. But we shouldn't underestimate the role of law and common institutions as the scaffolding that keeps this system together. The EU is a rule-bound institution, the rule of law, that matters, but also law is the major source of public power. In political science, we talk of the EU as a regulatory state. In other words, law is one of its major power resources when it comes to generating action and creating effect. It doesn't have anything like the public finance capacity or the taxation capacity of traditional nation states. So anything that impacts on law and law in the EU and of the EU is not just a question of the legal order of the EU, but in my view also the polity. So does that mean that the Karlsruhe judgment, this judgment is, as was, I mean, the newspaper is a mortal blow, shock waves unravel the EU, panic, Karlsruhe has gone rogue? No. It is to be expected in compound political systems, multi-jurisdictional systems, that we will have crises, tensions, and conflict. It is to be expected. So what matters, I think, in the longer term is how this is handled and what its consequences are, rather than the judgment in and of itself will unravel the EU. It also matters, I think, because this was a German institution and the EU has never had a crisis made in Germany. It has had multiple crises made elsewhere with consequences for Germany and Germany required to solve. But we've never had a quite made in Germany mark on an EU crisis. And this would be something, in my view, in terms simply of the structural forces at play in the EU, would be extremely worrying. Germany is not a hegemon. despite the literature that says it is, reluctant or otherwise, but it is an indispensable state in the EU. And of course, for Germany itself, membership of the EU is part of the raison d'être of the state. So there's a very strong link between Germany as a state and Germany as a member of the EU. So this, in my view, is a challenge that has to be handled with delicacy. And there are, firstly, the institutional challenges within Germany, the relationship between the German government and Bundestag on the one hand, the will of the people, and the two independent institutions, Karlsruhe and the Bundesbank. Then there's the relationship between German institutions and the EU, particularly the ECB and the court. And then there is also the demonstration effect and the purposes to which this judgment will be put by the Eurosceptics, as has already been mentioned, by the authoritarians at the table. And in my view, interestingly, I think the authoritarians at the table and what they've done to their domestic legal systems is much more problematic for the EU than the Karlsruhe judgment. Why do I say that? Not because it's unimportant, not because there aren't very serious challenges, but I think there's two ways of thinking about this. How will the German system and the EU system handle this in this period? And then what are the longer term consequences? In this particular period, even though everything on the surface is very stable, no one is saying anything other than the ECB, Lagarde said undeterred, the Court of Justice said reasserted supremacy, but the ducks are working very hard below the surface to try to find a way out of this that will not lead to a constitutional crisis, either within Germany or within the EU, and neither are desirable. So where can they, I think we're in the realm of pragmatism now and a jurisdictional dialogue, and also a dialogue between the Bundesbank and the ECB on the one hand, and then Berlin on the other. So I would expect the Bundesbank to play a role in transmitting into the German system something approximating a proportionality test. In other words, more on proportionality. The ECB will not do this. The ECB should not do this. It should not have its name on anything that says it can produce documents that are taken by the Bundesbank and thereafter transferred to Berlin. But the ECB has got to maintain its independence. I take very seriously what Georg said about the undermining of the myth of the ECB, because I think he is right in saying that the fiscal side of EMU must be built. That I think we see with COVID-19, there are tentative attempts to do that, but EMU will require a bank of last resort, and it will require forever, in my view, and whatever it takes ECB. So in however this is handled, the delicacy of the position of the ECB has got to be taken very seriously. There also was one of the German MEPs, Sven Simon, I think his name was, he wrote to Lagarde asking for an outline of the proportionality tests. And it is quite acceptable and normal for the ECB to reply to parliamentary questions from the European Parliament, because that stays within the structure of accountability, it stays within the proper structure of levels. So I would say, I would expect it's not in Germany's interests that there is a constitutional crisis, either in the EU or in Germany, because of this judgment. So I would expect interinstitutional dialogue, informal, and then gradually a solution emerges. Will this be adequate to the demands of Karlsruhe is another matter, but I think Karlsruhe would be advised to thread extremely carefully in the next phase. And then my final thought is, does what has happened require a longer term treaty change in order to prevent potential interjurisdictional conflicts that can break the system? So I think provided the system can handle the conflicts and the contestation without deep constitutional crises, either in a member state or collectively, then no need for treaty change. But if you as lawyers tell me that it is necessary, then I think that's for the longer term response. And I'll leave it there.
Thank you, Bridget. Thank you for those wise and considered reflections. So I think in our 4 presentations, we've looked back to the past, and particularly with Gavin's presentation at the outset. With Bridget's, we've moved forward to consider the implications and suggestions from the future. I think the presentations involved micro as well as macro, legal as well as financial. So we have a number of questions, as you might expect, from the floor. So the first question asks whether the German state has exposed itself to liability as a result of this. So David, perhaps you might address this one.
Sure, Blanaid, thanks for that. I assume that's in the context of member state liability for breaches of EU law. And of course, the Court of Justice has confirmed in the Kobler case that the member state can be liable for breaches which are carried out by the courts of the member state. So in principle, Germany could be, but when you look at the conditions for liability, you run into problems straight away. First of all, the rule of EU law that's been breached has to confer rights on the individuals, and I don't think the rules in questions here are of that nature. Secondly, there needs to be a sufficiently serious breach of EU law. And thirdly, there needs to be a causal connection between the breach of EU law. And I think that when you look at the rules in question here, given their nature, they're not of the sort that would confer rights on individuals. So I think an individual would have a very hard time indeed bringing such a case against the German state, even if in theory it might be possible.
Thank you. Another question, a really interesting question, asks whether the panel might see any analogy with how the UK courts might tolerate the ECJ jurisprudence after Brexit. So I'm not sure who would like to handle that one.
I think that's a very different issue, to be honest. This is a situation where we actually do have legally binding authority. At least that's something that the ECJ has been saying. And then a lower ranking court has been rebelled against this. However, in the Brexit agreement, if we have one day, this is one of the big negotiation factors that they have to hammer out, and one of the most disputed issues, right? Who has ultimate jurisdiction? But I'm sure that they will have a contractual solution for that problem, right? If there is going to be an agreement, then they will have one. And if not, then we don't have an agreement, then we don't have a problem. So I don't think the two are necessarily comparable, honestly.
Thank you. So another question, a slightly provocative question, asks why would the panel have a view as to whether the media, including academic commentators, reacted so dramatically to the judgment and drew such conclusions? Because certainly there's a degree of calmness in all the presentations which wasn't evident perhaps at the media level.
I think, if I may just come in on that, I'm sure Bridget has something useful to say on it as well, but I think the media reacted in it because it is actually a very dramatic ruling. Something very serious happened here, and that is that in the state, which is probably, in terms of its its financial input, in terms of its political and economic power, the most powerful state in the European Union, it rejected, if you like, and turned down the most fundamental obligation that a court has in the European Union legal order, which is to respect the rulings of the European Court of Justice under Article 267. So it is a kind of an open revolt. It's true that the problems it gives rise to are not necessarily immediate ones, in the sense that, I mean, the PSPP, most of its effects have been gone through already at this stage. So it doesn't really, you know, something will come up in terms of the proportionality. You know, maybe the Bundesbank will come up with some kind of statement in relation to it. So something can be done, but it's an extremely difficult situation, and the solutions to it are not obvious as well. I think myself, part of the solution for it will be the kind of solution we saw in Solange 2 and in Honeywell, and that is actually the Bundesverfassungsgericht backing down, because I think the level of control that it is looking for is simply unworkable. The test to try to apply the new test of proportionality is unworkable. Basically, you know, instead of you know, using proportionality as a test of the least disruptive intervention in the monetary field that the European Central Bank could have, which is what proportionality is supposed to do, it defined it as balancing between conflicting policy objectives between monetary and economic policies. It required the European Central Bank to take into account you know, effects outside the boundaries of monetary policy, and actually it actually required the European Central Bank to violate, I think, Article 127.1, which requires that its primary objective be the maintenance of price stability, and that economic issues are not allowed to prejudice that. So it set an impossible task for the European Central Bank to operate in. The European Central Bank has been crucial to rescuing Europe from the, as Georg has pointed out, from a financial crisis. It needs to be free, it needs to be unshackled, and it needs to be able to get its job done. And to have the Bundesverfassungsgericht coming in here and stomping all over the kind of discretion that the European Central Bank needs to get its job done is a major crisis. So it's not an immediate crisis, but it's a slow-burning crisis, and it could ultimately, if not dealt with, lead to both the unraveling of economic and monetary union and to the European Court of Justice. So it's a hugely significant ruling, and I wouldn't want to underplay that.
Would anyone else in the panel like to add to that or make a comment in response?
So I agree with what Gavin has said. It's a really important, significant ruling with potentially very serious consequences for the EU. That, I think, can't be gainsaid. What we have to be careful of, though, is we should anticipate interjurisdictional tensions, I think, in any federal, quasi-federal system, and the EU's legal order is the most federal aspect of the EU. And I also think there's a tendency for a rush to judgment on challenges that the EU faces. So since January, the EU was going to unravel on the basis of its response to COVID-19 and on the basis of the Karlsruhe judgment. And I just think there's no evidence to suggest that that is likely. So I think we need, it's a question of, if you Google today, the EU is, the first 4 responses you'll get is doomed, gone, over, etc., etc. So we have to be careful, particularly as scholars, not to constantly revert to the existential stuff. When saying that, I don't want to in any way downplay the dangers that a judgment like this has for the longer term. But given that it was a constitutional court, and for Germany, the EU is absolutely central to its raison d'etat, Germany will handle this, and the German institutions and EU institutions will handle it. In fact, I would not favor the Commission taking an infringement proceeding on this. I think that would simply escalate conflict, and then you end up with the ECJ reiterating supremacy and Karlsruhe saying no. So I think this is a matter of interinstitutional smoothing, let's say.
Okay, thank you. I'm afraid I know we have more questions, but we've run out of time now at this stage. So I want to thank our excellent panelists. I think that's a perfect place to finish, Bridget, but I want to thank all four of you for really excellent presentations and sharing your expertise and insight with us. I also want to take just the opportunity to remind the audience that the second of these sessions will be on the 25th of June. That addresses the pandemic and the single market, and it'll look at developments in competition law, state aid and public procurement. Finally, just to thank my co-organisers, Aileen Kavanagh and Stephen Britton, and to thank Maeve and Sean for the technology. So thank you. I hope this was useful, and the recording will be available for everyone. Thank you.
Thanks so much, Blanaid.
Thanks, Blanaid.
Bye-bye.
Thank you, bye-bye. Thanks so much, Blanaid.
Thanks, Blanaid.